Be ready. Start. By way of present petition under Article 226 of the Constitution of India, the petitioner company engaged in the business of manufacturing of paraffin wax has prayed for the following reliefs: that your lordships may be pleased to issue a writ of mandamus or a writ in the nature of mandamus or any other appropriate writ, direction or order holding and declaring that Section 87 of the Finance Act 1997 is ultra-virus, Articles 14, 19, Bracket 1, Clause G and 265 as well as Entry 84 of the Union List to the 7th Schedule of the Constitution of India and also ultra-virus Section 11A of the Central Excise Act, and be further pleased to strike down Section 87 of the Finance Act 1997 as ultra-virus and unconstitutional. That this Honorable Court may be pleased to issue an appropriate writ, direction or order under Article 226 of the Constitution of India declaring that the notification number 14/97 is ultra-virus and unconstitutional insofar as it is sought to be applied to the first petitioner in respect of import of its known APM products. That your lordships may be pleased to issue a writ of mandamus or a writ in the nature of mandamus or any other appropriate writ, direction or order holding and declaring that the case of the petitioners is covered under Rule 57B of Central Excise Rules 1944 and consequently the provisions of notification number 14/97 Central Excise dated 3/5/97 and Section 87 of the Finance Act 1997 are not applicable in the petitioner's case. That your lordships may be pleased to issue a writ of mandamus or a writ in the nature of mandamus or any other appropriate writ, direction or order setting aside the demand raised by the respondents, their servants and agents on the ground that the petitioners were entitled to take credit of duty paid on paraffin wax only to the extent of 10% ad valorem from 23/7/1996. That your lordships may be pleased to issue a writ of mandamus or a writ of prohibition or any other appropriate writ, direction or order completely and permanently prohibiting the respondents, their servants and agents from taking any action against the petitioners in pursuance of notification dated 3/5/1997 and Section 87 of the Finance Act 1997. Pending hearing and final disposal of the present petition, your lordships may be pleased to restrain the respondents, their servants and agents from implementing the provisions of notification dated 3/5/1997 and Section 87 of the Finance Act 1997 against the petitioners. This appeal by special leave has been filed against the judgment and order dated 20/12/2000 of the High Court of Punjab and Haryana at Chandigarh, by which the revision preferred by the appellant against the order of eviction passed against him by the rent controller as affirmed by the appellate authority was dismissed. Before examining the legal issues raised by the learned counsel for the parties, it will be convenient to notice the facts of the case in brief. The respondent, Dr. Ramendra Pal Singh Sethi, is a dental surgeon and he is co-owner along with his wife of a premises described as shop cum flat for short SCF in sector 37A, Chandigarh, in which father of the appellant, late O.P. Vij, was a tenant. The respondent filed a petition for eviction of O.P. Vij on the grounds inter alia that he was having his clinic in house number 5, sector 16A, Chandigarh, but the owner of the said premises, namely Shri Vasant Singh, had filed an eviction petition against him on the ground that he was a specified landlord within the meaning of section 2HH of the East Punjab Urban Rent Restriction Act 1949, for short 1949 Act, and the said petition was pending adjudication before the rent controller. The respondent wanted to set up a bigger dental clinic with modern gadgets, more number of dental chairs, provision for X-ray examination and radio video graphs and other facilities, for which the space required was wholly inadequate in the rented premises currently in his occupation. The tenant O.P. Vij contested the eviction petition on various grounds, and the principal ground urged was that eviction of a tenant cannot be sought on the ground of personal requirement of the landlord under the relevant provisions of East Punjab Urban Rent Restriction Extension to Chandigarh Act 1974 or the amendment made to the said act in the year 1982. The rent controller, after a thorough examination of evidence on record, allowed the eviction petition by the judgment and order dated 16/9/1999, and the said order was affirmed in appeal by the appellate authority on 16/11/2000. During the pendency of the appeal, the original tenant O.P. Vij died, and his legal heir, including the present appellant Rakesh Vij, who is his son, were substituted in his place. Rakesh Vij then preferred a revision under section 15(5) of the 1949 Act in the High Court, but the same was dismissed on 20/12/2000.